Good morning to the student. Welcome to you all again in online classes. Now we are going to discuss the law related to the female Hindu dying intestate. As you know, last time we have discussed if a male Hindu dying intestate, who will his heirs. For there we have already seen section 6 and section 8. Now, if a female Hindu dying intestate, then section 15 subclause 1, section 16 subclause 2, and thereafter section 16 will be applicable here. Section 15 subclause 1 talks about the if a female dying intestate, the first property will devolve to the son, thereafter her daughters and her husband. Here, son include the children of a predeceased son and children of a predeceased daughter. So suppose that if a female dying intestate, leaving behind her one son, one daughter and husband, then all will get the 1/3 of the property. If there is no her son, daughter and husband at the time of her death, then property will devolve to the category second, which talked about the heirs of the husband. How will you know who is the heirs of the husband? Again, we have to see section 8 of the Hindu Succession Act 1956, which talks about the list 1, where 16% were there. If there is no 16%, then we have to see list 2nd, where 23rd% were there. If there is no 33rd% of the deceased available, then we will see the agnatic heirs, thereafter his cognatic heirs. So these are a very comprehensive list under section 8 of the Hindu Succession Acts, for where we will determine the heirs of the husband. If there is no heirs of the husband available, then the property will go to the mother and father of the deceased female. If there is no mother and father of the deceased female, then property will go to the heirs of the father. Again, we have to see section 8 of the Hindu Succession Act, which talks about the if a male Hindu dying intestate. And lastly, property will go to the heirs of the mother. For your kind information, my dear student, it is a general rule of the succession. General means it is talks about the general things. Now, not understanding section 15 subclass 2 talks about not with understanding anything in class 1. It means that ये list के होते हुए भी, if the female inherited property from her parental side, then we will not see this list. If the property if the property she has inherited from her parental side, then in the absence of her son and daughter, property will not go to the husband, neither here or the other husband. Property will go directly to the his mother and father. So meaning thereby that if she has inherited her property from her parental side, then property will go to the parent side. Likewise, if she has inherited her property from in-laws' homes, then the property in the absence of his son, daughter and husband and here the husband, property will not devolve to C, D and E class. I think that the objective behind this rule is very clear, that whatever the property she has inherited from her parental side, after her death, the property will not go to her husband's side. If the property she has inherited from her in-laws home, then property will not go to her parent side. So it is a specific rule which talks about the section 15 subclass 2. For your kind information, now if she has not inherited any property from her parent side, neither any property from her in-laws home, then what kind of the rule will be applicable to her? For this, a very important case reached before the Supreme Court of this country, which talks about the name of that case is Om Prakash versus Radha Charan, EIR 2009. It is a very interesting case, and this case, when judges itself themselves realize that it is one of the great injustice they were doing at that time, but they were totally helpless because of this clause. Now come to the fact of the case. See, one girl got married. After 4 months of her marriage, her husband died by snake biting, and her brother-in-law thrown her out from her in-laws home, and she again came to her parent side, parental homes. Her father again assisted her, and she again started to her schooling. And now, when after the 43 years of 43 years of age, when she died, leaving behind a very huge sum of the property. She at that time she was a lot of bank balance, a provident fund, and so many other properties she has left behind her. After her death, her parents, because parents was the only caretaker of her parents claim over that property, and other side, brother-in-law, those who were thrown her out from the her in-laws home, again came and claimed over the property of the deceased. When the Supreme Court discussed all this fact of this case, and when if you see the rules, after her death, first, because there is she has not inherited her property from her parental side as well as the in-laws home side. She has earned all the property. So general rule of the succession will be applied here. In the absence of her son, daughter, and husband, the property will go to the heirs of the husband, because heirs of the husband, under the heir of the husband, list second, deceased brother is also available. So mother and father were placed under the third category. So if the heirs of the husband were available, then property will not go to the husband and parent side. So here all the property ultimately went to the brother-in-law. So it is one of the great injustice. But now the question arises: if she has having the separate property, then under this case, which law will be prevail here? It is very difficult, because half of the life women has to live with her parents side, and half of the life she has to live with her in-laws home side. So under these circumstances, it is a suggestion that half of the property should be go to her parental side, and half of the property should go to her in-laws side. So it is a very comprehensive list of the succession. But again, I like to repeat here that it is a general rule of the succession. And section 15 subclause 1 talks about the general rule of the succession, whereas section 15 subclause 2 talks about the specific rules of the succession. So I think, dear student, you have all able to understand the section 15 and 16. So with this, now I would like to sum up. Thank you very much.